Good morning. Can I please check in on one of the files?
Yes, ma'am. What's your last three on the case number?
937.
All right, I have you checked in. You can mute your microphone and wait for the judge to call upon you, okay?
Appreciate it. Thank you.
Yes, ma'am.
That's great. Can I check in?
Yes, sir. Hello, how you doing, sir?
I'm doing fine.
All right, what's your last name and last three in your case, sir?
Right. And you said what was the other question?
The last three on your case.
Hold on, let me grab that. Uh, 837.
Yes, sir. I have you checked in. You can mute your microphone and wait for the judge to call upon you, okay?
Okay.
Sir.
All right, this is case number 15-123233. This is American Road Services Company versus Katie Reyes Velez. The matter is before the court, set on for a pretrial conference on today's date. Your appearance at this time for the plaintiff, please.
Good morning, Your Honor. Tiffany Williams on behalf of plaintiff P number 74809.
All right, thank you. Good morning to you, Ms. Williams. I'm looking now for defendant Reyes. If you're on the Zoom or someone representing defendant, please say something at this time. All right. So, Madam Counsel, have you spoken with the defendant in this matter, or any counsel representing the defendant regarding this matter?
I have not spoken to opposing counsel since the deposition that took place. I think it was a couple of weeks now. I haven't spoken back to him, but with the exception of today, he's been active in the case. I wasn't sure if he had someone standing in. I was trying to wait to see if someone was standing in for him, and I just didn't recognize the name.
Right. All right. That's kind of what I'm looking at as well. So once again, if you're out there on the American Road Service Company versus Reyes Velez case, please say something at this time. All right. So what's the status of this? Sounds like you've gone pretty far on the road with discovery. Have you got everything completed in that regard, Madam Counsel?
Yes, Your Honor. I believe we're done with discovery. It was really American Road that wanted discovery. So that has been completed, and it's just kind of what my client's position is going to be post the deposition of the defendant.
All right, well, what I'm going to do, we did get a notice to the other side on this, and I don't know why I did not hear.
Your Honor, if I may, I wouldn't be opposed if we adjourned it out. I wouldn't want to do anything as far as any defaults. I don't even know if that's necessarily something the court was even entertaining, but if I can make a request for it to be adjourned out, and then that way I can reach out to the opposing counsel and make sure they know of the new date.
Right. Yeah, that's kind of what I had in mind, counsel. So I'm going to go ahead and send it over. All right. Yeah, I'm going to go ahead and set a new date on it. Just 1 second. All right. All right, so I'm going to send it out in a few weeks, counsel, and give you a specific date now. We will be sending out another notice, but also if you would reach out and make sure that the other side knows about the date, that would be helpful as well. Madam Clerk?
Yes, sure.
March 29th, at 9:45, March 29th, 9:45. I'll be the next action.
Okay, thank you, Your Honor. March 29th at 9:45. Okay, thank you, Your Honor.
Thank you.
Okay, take care.
All right, the court calls at this time, case number 21-166-807. This is U.S. Rehabilitation and Health Services versus the City of Detroit. The matter is before the court, having been joined by the submission of an answer to the complaint in this matter. Counsel for U.S. Rehab, your appearance at this time, please.
Good morning, Your Honor. Christina Abro, P78224, here on behalf of U.S. Rehab.
Good morning
Calvert
to you.
Bailey, P42409, on behalf of defendant City of Detroit.
All right, Mr. Bailey, good morning to you, sir. As
Good morning,
well.
Your Honor.
Looks like this is a first hearing. The court set it up for a scheduling conference on today's date. Have you all had an opportunity to talk about this to see whether or not there's any room to start meaningfully having discussions at this time?
Judge, we actually have not spoken. However, I did send a mandatory disclosures as well as a stip to transfer over to defense on March 3rd. Our balance, since we pulled the new bills and records from our client, has increased over the jurisdictional limit. So at this time, I have a balance of 48,490. I would ask that defense stipulate to transfer to Wayne County Circuit Court, if that's okay, and respond to my email.
I hadn't had a chance, Your Honor. I have no objection.
All right, well, I do have a lot of jurisdiction, but not that much.
Yeah.
So it makes sense. The stipulation for transfer of jurisdiction makes sense here. And the court will sign an order consistent therewith. You can submit that order via email. Let me give you the email address so that the court can sign off on the stipulated transfer. And that is Latifah, latifah.hunter@36districtcourt.org.
Latifah.hunter@36districtcourt.org.
That's correct, counsel.
Thank you, Judge.
Thank you.
Thank you, Your Honor.
Thank you, sir.
You too, Your Honor.
All right, the court is calling case number 21-16937. This is Andrea Wilson versus Nationwide Mutual Fire Insurance. The matter is before the court for a pretrial conference. The court previously entered a scheduling order and sent the matter over today for a final pretrial conference. Your appearance for Wilson, please. Andrea Wilson.
Good morning, Your Honor. Helen Cooley on behalf of plaintiff P number 84581.
Thank you. Good morning to you, Ms. Coley. With regard to Nationwide, your appearance at this time, please.
Good morning, Your Honor. Lauren Brzezinski on behalf of defendant P75259.
All right. Good morning to you, Ms. Brzezinski, as well. All right. So you've gone through discovery. Has everybody gotten what they were looking for? That's the first question. Then is compound, because the next question is have you began talking to see if you could get this resolved. So answer it whichever way you want to. Ms. Coley, you get to go first.
Your Honor, we did have some discovery exchange recently. We had the plaintiff's deposition. However, defendant is asking for the caregiver deposition and also requesting more records. So if the court is not opposed, if we can have an adjournment for 30 to 60 days in hopes we can get everything together and hopefully settle the case.
Ms. Brzezinski?
Yes, Your Honor, we do request additional time. I would request the 60 days if possible. The medical records we had addressed at the last pretrial. We did get the authorizations in February, but obviously they had to be sent out, and then the company, the providers need to be able to respond to those. We do not have those records yet. We had set the deposition of the caregiver at the same time as plaintiffs, but it was indicated that plaintiff's counsel could not produce her. So we have in the process of subpoenaing her, which would address the claim for care that's being provided by the plaintiff or claimed by the plaintiff in this case. So we do think that that would be reasonable discovery to be allowed to be completed within the next, hopefully 30 to 60 days, please.
All right. It does appear that the parties have been working towards moving the case forward by acquiring the appropriate information and getting the case in position for either trial or some resolution. Accordingly, the court will grant an extension of discovery in this matter and will set a new date. It's April the 7th.
She wants 60 days, but
That's about somewhere.
yeah, April, you said first week in April. Are you giving her 60 days or 30?
Well, I'm trying to put it at about
May?
4 to 5.
Oh, okay, all right, so you want May 13th, April 13th, or April the 21st?
April 21st. All right. 4/21. 22. Sorry. Actually,
Oh.
4/21, 22 will be the return date on this matter. I'm going to set it at 9:30 a.m. I'm also, as I move this forward, you will note the order that was previously sent to you. It allowed for you to have motions heard on the final pretrial conference. That is also true with respect to the 21st, the 21st of April, 2022. If it occurs to you that you wish to file a motion, you can set it for hearing on that date, so long as you allow the other side to have at least 7 days to respond to the motion before the hearing date. So that will apply with this extension as well.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you. Good day to the two of you.
You too.
All right, the court is called in case number 21-169-711. This is Denise Galloway versus Progressive Michigan Insurance Company. The matter is set on today for a hearing. I see that there has been some exchange of information and the court has received the plaintiff's witness list as well. Your appearance for the plaintiff as well.
Good morning again, Your Honor. Helen Cooley on behalf of plaintiff.
Good morning to you, Madam Counsel. Again, all right, let's see who we have here for Progressive. Your appearance at this time, please. One for Progressive Insurance. If you're present, please say something. So, Ms. Foley, what's going on here?
Your Honor, I don't see the attorney on the case. So recently, we, like you just indicated, we exchanged witness lists, initial disclosures. No discovery have been exchanged as of yet. There's nothing going on other than, you know, discovery has to be started. In terms of plaintiff, we're not looking for any discovery. However, I'm not sure about defense.
All right, very well. So what I will do, Madam Counsel, I'm going to go ahead and set a discovery order in place regarding this matter with a cutoff date of April 21. Let's go a little bit further.
May. May the 1st, May the 2nd, I'm sorry. One the first.
No.
Oh, so you want to talk maybe the week, the second week, May 16th or May 9th?
May 9th. 5/9/22 at 9:30 a.m. That'll be the next hearing. The discovery will run through that date. And my order will also provide for the filing of motions as positive or otherwise to be set for hearing on that date if the parties desire to do so. As long as the other side has at least 7 days to respond prior to the hearing. If it becomes necessary to set motion hearing dates beyond that time, I'll do so. But if the parties in the interim decide if they wish to file a motion out here on 5. So I'm going to get that more out to you and to the other side with the discovery dates.
Thank you, Your Honor.
Anything else at this time?
No, Your Honor, thank you.
All right, thank you. Good day to you.
You too, thank you.
The court now calls case number 21-169116. This is Credit Acceptance Corporation versus Demetrius Martin. The matter is before the court, having been joined by the submission of an answer to the complaint in this matter. The complaint alleges damages of $7,462.50. Your appearance for credit acceptance, please. Credit acceptance. The record should reflect that this matter is set on for 10:00 a.m. Do I have Demetrius Martin on this Zoom?
Yes, Your Honor.
All right. Good morning to you, Mr. Martin.
Good morning.
I'm looking now for someone from Credit Acceptance. And let me ask you, Mr. Martin, have you spoken with anybody from Credit Acceptance regarding this matter?
No.
I had it set up for review. So let's see what happens. So you were here in front of me one time before, correct?
Yes, sir.
So what did we decide at that time? Because I see that I noted something about doing a review on today's date.
I had filed bankruptcy, so I'm not sure if that's why they haven't it's not in here or not.
Okay, when did you file bankruptcy, sir?
Probably about 3 weeks ago.
All right, and did you list this indebtedness on the bankruptcy petition?
Yes.
All right. Yeah, that would stop things. They should have submitted a copy to me, in particular order to stay the proceedings while the bankruptcy matter is proceeding. Your bankruptcy has not been dismissed, has it?
No, not yet.
All right, so what I'm going to do is I'm going to go ahead and adjourn this over based upon the representations that you made, and I'm going to set a new date for it. If I get a document that the plaintiff is supposed to give me, then that will close the file temporarily while the bankruptcy matter is going forward. But right now, I don't have such a document in the file. What I will do is I will simply set this over, and I'm going to set it over until April the 7th. Is that all right? So April 7th, 2022 at 10:00 p.m. Will be the next date on this matter, April the 7th at 10:00 p.m. You get another notice. That's when you're going to come back into the Zoom. Right.
Okay, sir.
All right.
Okay, thank you, sir.
The court now calls case number 21-172-837. This is Ford Field Company LLC versus Angelo Wright. The matter is before the court on a set for a hearing. The matter arrives to the court by virtue of a change of venue from the previous court, which which was the South of District Court. Right, your appearance for the plaintiff regarding this matter, please.
Good morning, Your Honor. Deborah Winslow, P63179, on behalf of the plaintiff Ford Motor Credit Company.
Thank you, Ms. Winslow. Good morning to you, ma'am. I'm looking for Mr. Angelo Wright. I believe I see him there. Good morning to you, sir.
Good morning, sir.
You are,
Judge,
you are Angelo Wright, is that correct, sir?
I am.
All right, thank you. So this matter has been sent over to this court, and what would initially happen would be that this would, the court will begin proceedings by allowing for a period of discovery for the parties to exchange information. Has there been any discussions on resolving this matter in any kind of way? Ms. Winslow?
There has previously, Your Honor, and if we could have a moment in the breakout room possibly, just to talk briefly, would that be possible?
Sure. All right, so Mr. Wright, I'm going to send you to a breakout room with Ms. Winslow. That will give you guys an opportunity to talk about this matter, then you'll be able to go back in, come back into the hearing. So I'm sending you to breakout room number 1, just received the notification. And Ms. Winslow, there's your notification as well.
Thank you.
Okay, thank you.
Yes, sir. All right, this is case number. Case number 21-160461. This is Precise MRI of Michigan PLLC versus City of Detroit. The matter is before the court on the adjourned date of hearing. All right, your appearance for Precise, please.
Good morning, Your Honor. Danny J. Dorping on behalf of plaintiff, P number 80645.
Thank you, counsel. Good morning to you, sir. All right, for the City of Detroit, if you will.
Morning, Your Honor. Ben Patterson on behalf of defendant City of Detroit, P number 85118.
All right, thank you, Mr. Patterson. Good morning to you as well. I see that there have been some discovery activities in this file, requests to admit and things along those lines. So go ahead and update me, plaintiff. Tell me where you think things are at this point, sir.
We recently just finished discovery. We plan on tendering an offer and we're hopeful we can get this one resolved. I believe brother counsel did file a motion to dismiss or motion to deem our RTAs admitted because they were submitted late, but I was looking at some email correspondences and they were in fact sent to brother counsel on time. So I'm not sure if you're withdrawing that or going forward with that.
That motion be moved about now, Mr. Patterson, what's your position, sir?
Your Honor, with respect to our motion, I'm not aware of what plaintiff's counsel is referring to in terms of timely service. The request to admit responses we received by email on March 1st. They were due by February 23rd. The document attached to the email sent on March 1st had a proof of service of February 24th. So my understanding is that they were untimely. So we went ahead and filed a motion based on untimely they're deemed admitted. So that's the current status in terms of the motion. The city also produced the redacted claim file, provided disclosures. I believe we, on the 23rd by email, received discovery requests from plaintiff, which if the matter is not dismissed, we will respond to when they are due.
All right. So, so counsel, what happened with the regard to the request to admit answers? You indicated that something was sent prior to the items being directed to Mr. Patterson.
Yeah, we My assistant indicated to me they were mailed timely. However, we received a email correspondence, I believe, from Ben or his assistant indicating they wanted their discovery responses. So then we just forwarded them via email as well.
All right, very well. Under the circumstances, I'm going to go ahead and deny the motion for summary disposition. I believe that based upon everything that I've heard, there was a good faith effort to, in fact, respond timely to the request to admit, and so the motion be denied at this time. Are there any other issues of discovery that are outstanding at this time?
I believe they just have our answers to respond to now, or our discovery to respond to right now.
Very well. So have you tendered an offer? Has there been any discussion along those lines to try and get this resolved?
No, but we do plan on tendering an offer.
Would it be at all fruitful to have a discussion today, Mr. Patterson?
Your Honor, I'm happy to speak with plaintiff's counsel. I will say that the situation here and the reason why the claim was denied and is that our indication is that the right hip, which was treated, that was what was reviewed on the precise MRI, was a pre-existing injury from a workers' comp claim before the accident. And so I would ask, Your Honor, if you're denying our motion, that we be given an opportunity to file another motion because it is plaintiff's burden to establish that it is related. In terms of discovery, I mean, I think we have what we need. We'll be responding to plaintiff's discovery requests, but I would ask, I do think this should be something rolled on the motion. That being said, I'm happy to hear from plaintiff's counsel, and if we can get this resolved without burdening the court further, I'm happy to entertain that and work on it. But that's my view of the case. We don't view it as related, that our indication is that it was pre-existing.
All right, got it. All right, that's what I'm going to do then, and I will set it up on a calendar that will allow you an opportunity to file your motion and to be heard on the motion. And I'm also going to today I'm going to send you to a breakout room just to kind of begin to think about whether or not there's some room to resolve this, and if not, we'll already have a date to come back for a motion here. So I'm going to set it over for sort of April.
April 13th.
April the 13th will be the motion hearing date, and that's going to be at 10 o'clock a.m. April 13th, 2022 at 10 o'clock a.m. And either party may file any motion that they wish to file and be heard on that date, so long as the motion is filed with this court not later than the 25th of March, not later than the 25th of March. Any response to the motion would have to be filed on or before, on or before the 7th of April. On or before the 7th of April. And the court will hear it on April 13th.
Thank you, Judge.
Thank you, Your Honor.
25th for the filing of the motion. Let me send you to a breakout room. You don't have to stay long, but you don't have to leave early. So see if there's room to begin a process, and if it works out, all the best on that. And I'll see you on the next action.
Thank you, Your Honor.
Good morning, Judge.
Morning to you.
What's that case number again?
One I just called, that's
Yeah.
21-160-461.
Oh, one more time.
21-160-461.
Okay, thank you.
All right, welcome back, Madam Council, regarding suffix 837, the credit versus Angela Wright, and welcome back, Mr. Wright. All right, I know that you had some discussions, hopefully they've been fruitful.
I think they have, Your Honor. What we discussed, if we could have perhaps a 60-day discovery period, would that be possible? And then we're going to try to work this out with the dealership, apparently. So.
All right, that sounds reasonable. Mr. Wright, you understand what's being said here, sir?
Yes, sir, I do.
All right, so what I'm going to do is I'm going to set a date that's like 60 days out. That date is going to be a period that is open for discovery, the exchange of information and documents. Anything that you receive, Mr. Wright, you have to respond to. And if you wish to request documents or responses to any questions that you have, you can submit the same to Ms. Winslow, and she'll make sure that those items get answered and responded to. In the process, while this process is going on, I understand there'll be something of an investigation to try to figure out some issues regarding the dealership on this issue as well. So the new date to come back is going to be
The 9th, May 9th.
May 9th, 2022. And that's going to be at 9:45 a.m., May 9th, 2022 at 9:45 a.m. And both sides have the right to file motions or requests that the court decide an issue in this case, whether that issue decides the entire case or whether it decides only a part of this case, dispositive or non-dispositive motion with this court, and set that motion for hearing on the 9th of May of 2020 at 2022 at 9:45 a.m. The only requirement is that you have to give the other side at least 10 days to respond to the motion. So it can be set for hearing on the 9th, so long as the other party has at least 10 days before the hearing to respond to the motion. You will receive a letter from me that has that language in it. If you wish to file any motion dispositive or otherwise, you can do so. And I will hear it on the 9th of May. Now, that shortens the time that's normally allowed for motions for summary disposition by court order. The court is shortening the time for filing and the time for submitting any response.
And Your Honor, if I may, Mr. Wright did not file an answer in this matter officially. I don't believe, did you, Mr. Wright? I didn't get anything, just what you called in. So I don't know.
Yeah, I had just called in and then I submitted the paperwork over and then I got the court date. So that's the only thing that I've done on my behalf.
All right, wow, oh yeah, I see how you got set up for hearing here because of the transfer.
Right.
Right, so you kind of, you need to put something in writing, sir, regarding your answer to this matter. And you need to file it with the court and you need to submit a copy of it to Ms. Winslow. The complaint in this matter is a 5-paragraph complaint. And you need to put something in writing responding to each paragraph. And get that done right away. Are you able to do that, sir?
Can I get a copy of those 5 paragraphs sent to me?
That's the lawsuit that was filed against you. You should have that already. The complaint that was filed against you alleging damages of $1,102.
Yeah, I'm gonna need a copy of that. Can you send that to me, sir? I'm sorry.
What happened to the copy you had?
What I got is was a court date, and then I think it was like some served paper that they got served to my mom, but that's the only thing that I have. Was it in one of those?
Mhm.
Yeah, it should be in that package. That's the document that would be in that package called complaint.
Okay, yes, I think I have that. I think if that was what was served to my mom, then yeah, I have that.
All right, that's what you're gonna wanna look at that and then put something in writing as a response to that, right? So you have.
Yeah, I could do that. And where do you want me to submit that to?
Submit it to the 36th District Court and send a copy to Ms. Winslow.
Okay, and do I have to take it down there physically or
There's a way to submit it online, but you can certainly bring it to the second floor and file it on the second floor.
okay. And Ms. Winslow, to submit you a copy, do you have like can you text me something so I can send that information to you too?
You can just, our address is on that document. You can send it there or you could fax it to us.
Yeah,
Okay, I can do that.
Okay.
Once you get to that document, you'll see Ms. Winslow's address and information.
Okay, that's fine.
All right.
Thank
so,
you.
Thank you.
You're gonna need to go ahead and submit that. You gotta get your answer in, sir, by the 18th. The 21st. By the 21st of March.
By the 21st of March? Okay, I can do that.
Yeah, make sure that you get it in that in.
Okay, I can do that.
All right. All right. I wish you well. Good day to the two of you, and you'll get a copy of my order in the mail regarding these issues.
Thank you, Your Honor. Thank you,
Thank you,
Mr.
Your Honor.
Wright.
Thank you,
Okay.
Ms. Winslow.
All right, we'll be in touch.
All
Bye-bye.
right.
There, you good there?